Good day.
Good day, DCJ.
How are you?
I'm fine.
Good. Well, I'm fine too.
Yes.
Even if you didn't ask. You were a waiter at Wimpy for 10 years.
Yes, DCJ, but before that, due to poverty, just like many of us, at the age of 12, I had to go and seek for employment, and I was employed at the age of 12 as a gardener, and I worked up until I finished matric, and thereafter I started working at Wimpy as a waiter.
Mm-hmm. You were attending school whilst working as a gardener, I hope?
I was.
Okay.
During over the weekends, I will go to, with the permission from the school, because at that time, it was pre-1994. Permission, a letter from the school was required, and whenever you are approached by the agencies, you were supposed to produce that letter to show that you are there.
It was a school pass.
A school pass, yeah. Yes.
Yeah, I know about. I had one too. I was older, 3 years older than you when I started working, but I loved my job. I worked at an Edgar's store, handing out flyers and sweeping floors and baking tea, and I had that school pass.
Yes, thank you.
So how did you find that experience? I hope you were treated well.
I've tried to locate my employer as a gardener. He was, his name is Michael. Mm-hmm. I even go to the deeds office because that house is no longer owned by him. The reason why I wanted to see him, if he's still alive, was because on my first day, he made me dig a big hole just to plant just a small seed. And thereafter, he said to me, this seed will become a tree, and when it is big, it will give shade to other people at the time of need. So I want to be that kind of a person in future.
Wow. So have you been back to the house to look at your tree?
Yes, I even whenever I'm going past that house, sometimes it's intentionally so that I can see it. Whenever I'm going with my kids, I will always go to that house, but unfortunately it is owned by another family now.
Wow.
So I'm unable to get access to it.
So that experience actually built your character, if you listened to Mr. Michael, that is?
Yes.
All right.
Yes, as a waiter, yes, it was nice because the only thing that was required from you is to have a smile on your face as I'm still having that smile.
All right. So while you were working at Wimpy, you studied, if one tallies the times when you obtained your legal qualifications, and
Yes, that is correct, DCJ.
Okay.
From 1996, I started to enroll for my PPROC.
All right.
Yes.
And then went on to do your LLB and a postgrad diploma thereafter.
Yes.
Did you pay your way through university?
Sorry?
Did you pay for your own fees at university?
No, it was through the It was TEPSA at that stage.
Oh,
Now it's
oh.
NFAS,
All
NSFAS. Yes.
Okay. So once you got your legal qualifications, you became a legal advisor with Legal Wise.
Yes, DCJ, and I believe that it was through the court's intervention, because if you look at my CV, I started at Wimpy, at Legal Wise on the 4th of October 2000.
2000 until
Yes.
2001.
And
A little over a year.
yes, it was a permanent employment, and my father was bedridden. He was very sick, and my mother had passed away 10 months before my dad. And my father was unemployed at that time due to his sickness. And the reason why I say that it was God intervention, it's because that when I started on the 4th at Legal Wise, 10 days later, my father passed away, and my payday was going to be the 25th, and he was buried on the 21st of October. In short, DCJ, I approached the funeral parlor with the letter confirmation letter from Legal Wise to say that I will be able to pay for the funeral expenses. And on that strength of that letter from Legal Wise, and my father received a decent funeral service. And if you look at my CV, I did not stay long.
Yes, you didn't.
At Legal Wise, because 2 months later, I received a call from Legal Aid, South Africa. So that is why that it was God's intervention. That is what I believe, in order for me to bury my father.
Your father,
Yes.
yeah. Life is a way of working itself out, you know. So you did your articles and became an attorney within Legal Aid.
Yes, DCJ.
And you even became a unit manager there. You did well for yourself.
High Court unit manager.
Yeah.
Yes.
And then you took a leap and started your own law firm
Yes, DCJ.
in 2017.
In fact, I tendered my resignation at Legal Aid in December. Then on January, the 5th of January 2017, I opened my own law firm.
You felt strong enough to stand on your own 2 feet now.
Yes.
All right. So you ran this firm until 2020
Yes.
and then became a magistrate.
So in 2018, the firm was incorporated, and I involved 2 directors, that is Stirman and Makubane. Yes.
All right. Then you decided to join the bench and became a magistrate.
Yes, DCJ.
And you are now in acting. Are you still acting in the senior magistrate's
Yes,
position?
DCJ.
All right. In the civil and family law court.
Yes.
Did you get to do any criminal work?
From 2020, I'm only dealing with civil.
What kind of work did your practice conduct?
It's a general practice. Yes.
Okay. When did you start acting in the High Court? In 2016?
Yeah, on the 10th of October 2016.
All right. And you've had intermittent stints since until the end of last year?
Yes, on
According
the
to your
8th of
CV.
December
Yeah.
2022.
All right. And your application form reflects that you sat in both civil and criminal courts?
That's correct, DCJ.
Okay. Did you get an opportunity to write judgments during your acting stints?
That's correct, DCJ.
How many? Are you able to tell us?
When I counted them, they amount to plus or minus 30.
All right. You indicate that only one was taken on appeal. Well, not on appeal. An application for leave to appeal was sought and dismissed by the SCA.
Yes, DCJ, that's correct.
So your 30 judgments stand unchallenged to date.
Fortunately.
Okay. You don't have any reserved judgments. There are no partly heard matters.
None, DCJ. If you look at the last year, the session ended on the 2nd of December. But due to the fact that I was still having a criminal trial, which was a lengthy one, I approached my DJP, who was acting as JP at that time, to extend my appointment for 1 week. Then during that week, I finalized the criminal trial.
All right.
Yes.
Is your work up to date in the magistracy now, in your day job?
Up to date.
Okay.
Yes.
You mentioned that you have a partial disability
Yes, DCJ.
arising from a head injury.
Yes, DCJ.
When did you sustain that injury, if I may ask?
In 1994, DCJ.
So it's an old incident.
It's an old, yes.
Does it affect, well, you've managed to acquire all these fancy legal qualifications and do all these nice things you've done so far. So I can't imagine that it affects, it impedes you in any way in the execution of your duties in the workplace.
Yes. No, it affects me to the extent that my right-hand side sometimes become weak. I'm not a medical doctor, but I'm told by the medical practitioners that there is some condition which is fixed or permanent or affecting my brain nerve system, which makes my right-hand side to be weak.
All right.
Yes, and with that, I had to be given 15 minutes per hour at university in order to write my exams. So in a 3-hour paper, I was getting 45 minutes extra. But even though I was afforded that 45 minutes extra, I could not finish my paper. But I was able to pass, and my BProc, I was supposed to be doing it for 5 years, but I did it within 4 years, and my postgrad LLB, it was supposed to be 2 years, and I did it within 1 year.
All right. So this does not affect your cognitive abilities?
No,
All
not
right.
DCJ.
Are you able to, judges work really long hours as you would have experienced. Are you able to cope?
Yes, I am. Since from legal aid, as a legal aid practitioner working for the High Court, we used to receive thick files for criminal appeals, and one was expected to produce sets of arguments within a certain time and to be filed timelessly. And I was able to do that for all the years I practiced in the High Court.
Sorry, I'm not sure if I asked you this. What is the total period of time you acted?
When I counted, it gave me plus 35 weeks.
Okay.
Yes.
Over 30 weeks.
Over 30 weeks.
All right. One of the professional bodies says that you are not ready for permanent appointment. This is the Advocates for Transformation. And they don't support your candidature.
I've seen it, DCJ.
Do you have
and
anything to say to that? Do you think you are ready for
yes, I think I'm ready. Why I'm saying this, DCJ, in as much as I acknowledge their comment and I respect their organization, but I had given them my judgments, which is a criminal appeal and judgment, a criminal trial judgment, as well as a civil judgment. But they did not comment to say where I might have made mistakes or to show that I don't have sufficient civil experience. Just like other fellow bodies who commented on all my judgments.
Yeah. The GCB, for example, says your judgments appear to be well written and well reasoned.
Yes, DCJ.
Oh, well, I'll leave it to your JP to probe this further with you.
Yes.
I stop here for my own purposes and hand over to the other commissioners. JP?
Thank you, DCJ. Good morning, good afternoon, Mr. Zaca.
Thank you, JP.
We know each other for a very long time, from the BLA days.
Yes.
Yes, I just wanted to put that up front.
Yes.
Now, perhaps just before we get to AFT, I want to focus on your application
Yes.
because the LSSA supports you. I think, yes, it is the Law Society of South Africa, they support you. But they bring to your attention the errors that are in your application. And you sent a response, and you say you accept that there are minor typographical and spelling errors in my questionnaire, such as the first acting period, and you carry on. But the point I want to make is they are not minor. They are a lot of errors in your application.
I accept that.
But why is that so? Because as the position that you are applying to be a judge, it's another step, another level in the profession. And this body, I'm sure, is expected to receive a very well-prepared application when it comes from candidates. I have counted only in your application and your CV about 30 errors, 30.
I accept that. It might be that at the time when I was completing this questionnaire, I was not well, but that cannot be used as an excuse. But in executing my judicial function, I don't see any errors.
Yes, but you see, the difficulty I have as a JP, you haven't acted, for instance, under my supervision.
Yes.
So I don't know much your work other than we know each other from the BLA. So I take your application and read your judgments, and that's what would probably form part of the view that I would take and that I would submit to the commission. But with these errors, how do I say that we must go past them? Look at the covering letter. The covering letter has got capital letters in the middle of a sentence. And also your name is spelled incorrectly. Did you see that? Or is it spelled like that in your ID?
In my ID.
Or that is how it's spelled?
Yes.
Or because I was quite concerned. But having said that, it doesn't detract from the errors that I say are in your application. And you don't seem to have taken the time to update your CV because I will take you to the page in particular, which really concerns me. Page 23.
Yes.
So that's where you were listing the responsibilities. I assume of the responsibility, because it's not clear there as to what responsibilities were you talking about. I assume that these were the responsibilities in the law firm that you were dealing with. So for instance, in bullet 1, 2, 3, 4, 5, about 9 or 10 petition papers to the judge president of this division, as well as the Chief Justice of the Supreme Court of Appeal. So for me, you have not updated your CV properly, because you would not have that heading for the Supreme Court of Appeal.
That's correct.
What is the head of that court? How do we say it is?
The president.
Yes.
DCJ.
So it would not be the Chief Justice of the
Yes,
Supreme.
yes.
Yes. So those are some of the minor things that it's not minor for me. You say they are minor, but for me they are not minor, because the positions that we are filling as a division are for experienced judges that have retired. So we need a lot of experience, a lot of expertise, a lot of people that apply their minds when they do their work. So let's then leave from the errors in the application. Your strength seems to be the criminal background.
Yes, that's correct.
And I see that you have acted twice only for civil.
Yes, that's correct.
Yes. And I think one of the reasons why AFT says they don't know you is, even when I checked with the other judges whether you had acted in Durban, most of them said no, because they couldn't remember. But I only saw in your application that you say you acted in October 2018.
Yes, JP,
Yes.
you were there.
Yes.
It was at the time of one of the senior judges was not well, and I had to be roped in to fill that position for that senior judge.
Yes. Yeah, but the point I'm making is some time ago, more than 5 years ago. So you haven't
Yes.
been there
Yes,
recently. But then coming back to civil, don't you believe that you would benefit from more acting appointments and you concentrate more on civil?
I am of that view, JP, but with my position right now at the magistrate court, although the complexity of the matters, they are not the same, but I deal with a lot of civil matters.
Yes. Why I'm suggesting that, if you look at page 93 of your bundle, that is the matter that is your civil judgment.
Yes.
That you dealt with. But perhaps before I get into my question, if you look at page 105, you've put that order in, that is in my name, unfortunately. But what was the purpose for that page to be put there?
So it was mainly because I had ordered that the respondent company should be provisionally liquidated, and the return date was on the 25th of May, 2023. And on that day, when going back to the High Court to check what happened, and I could see that the matter was dealt with and finalized.
But I don't understand the importance of you putting that page in your application.
It was only that, Judge President.
Because I don't know whether you would have thought that they would appeal, your order was confirmed. So I was not sure as to what the purpose of putting that was.
When I went to the High Court to check on all of my matters, if they were appealed or not, I only find that there's only one matter which was taken on appeal. And this one, the civil judgment, was finalized and nothing more to show that it was taken on appeal or not.
But at that stage, you had granted a provisional order.
Yes, yes, Your Honor.
Would they have appealed it at that stage?
No.
Yes. So that's why I was confused as to, so let's look at that order that you granted. So how long did that judgment take you? Because it's not clear there as to when had you reserved it and when was it handed down? It was handed down on the 18th of November, 2022, but it doesn't show when had you reserved it?
Yes, it took me within 5 days, JP, because if you read at my judgment, it was argued, although it was argued by applicant only because the respondent counsel received instruction to terminate the mandate, and yes, it was within a week.
But that concerns me further because if you delivered your judgment on the 18th of November and then you give a return date as May 2023, why such a long period?
JP, I can only say that it was because the parties have approached me in chamber, and especially the applicants, because they were also concerned that the employees of the respondent, they were not notified, and the order had to include an order that this this order should be served on the employees in terms of in compliance with Section 197B of the Labor Relations Act. That was according to the applicant's counsel.
But that concerns me because the application, isn't the application ought to have been served on the company and the notice ought to have been placed on a notice board somewhere so that the employees could see? So if they told you this at the time of hearing the matter, that the employees were not aware, how then did you continue to deal with the matter?
I continued to deal with the matter because there was no application for postponement, 1. 2, the respondent papers also did not challenge that position that the employees were not served. In fact, the heads of arguments of the counsel who was appearing on behalf of the respondent make reference that that could be cured by sending the order to inform or disclose to the employees in compliance with Section 197 of Labor Relations Act.
Well, I think I'll leave that point there. Let's just go to the order that you granted in page 93 and page 104. You say, I accordingly proposed the granting of the following orders. Why must you propose to grant the order and not grant the order? Was that an order in the first place, if it's couched like that?
Yes, it was an order, but the word proposed, I will not take that any further.
That it concerns me because such orders you grant on appeals when you're sitting with another judge, and that other judge will then agree and order and would say it is so ordered, so that it doesn't become just a proposal.
I
So when
understand.
you leave it like that, it's then a proposal in my view.
I understand,
Yes.
Judge President.
Now, in that judgment, it was very difficult for me to follow the judgment itself. And because you seem to have, I don't know whether there was even an application for a postponement, but there was somebody who had appeared for the respondents, and I don't know what happened, because if you look at paragraph 14, there are various things that arise which I wasn't sure of. I was not sure whether the respondents knew that the matter was set down in the first place. Because if you read that Ms. Perumal, there was somewhere where it says the matter was not on the roll. In paragraph 15, it says an SMS message from a cell phone, and this is the evidence you accepted, by the way, from the bar. An SMS message from cell phone, which is from those attorneys, was read by applicant's counsel, confirming that the counsel instructed by Keith was in court this morning and left as he thought the matter was not on the roll. But Keith Joseph seemed to abide by the court's decision, they stated in the SMS. So I wasn't sure whether, if there was another advocate there for the matter, and then they believed that the matter was on the roll, what was the final? As I say, it's not clear from your judgment as I read it.
If you look at paragraph 14, down to the beginning of paragraph 15, it shows clearly that Ms. Perumal was on record and the notice of set down had been sent to their offices, and at that stage, Ms. Perumal was an attorney of record. And on 26 October 2022, that is where the twist came, when Ms. Perumal received a letter coming from Keith, from other attorneys to say that they have been instructed in this matter, but they were not going to ask for postponement on the day of hearing.
I think it's a complicated issue, because it seems to me that Ms. Perumal's mandate was terminated, and then there was this other advocate who had been appointed to act, who thought the matter was not on the roll. So it's quite a lot of issues. But then in your judgment, you also base most of the findings, or when you evaluate, on what Ms. Perumal had filed as the heads of argument. So it's, as I say, it was very confusing. But I think I'll move on from there and just say this. In talking to some of the colleagues about your application, some raised some concern that when you were acting, particularly in Pietermaritzburg, you had lots of visitors in your chambers. And these were the people from outside. Is that a fair observation? Because as you would know, the judge's space is very guided. And so they were concerned with a lot of traffic, so to say.
I won't comment much to that, but all what I know is that because I've been practicing in that court, in Pietermaritzburg High Court, most of the clerks or registrars and ushers, they would now and again come whenever, say, to greet or what. But I will tell the secretary not to allow them.
Yes.
But I cannot say that I had a lot of visitors from outside.
Yes. Perhaps just one or two things then generally on the civil law. I just want to check at what stage do the litigants bring an application for summary judgment?
When the summons have been served to the defendant and the defendant has filed a notice of intention to defend and thereafter filed the defendant's plea, and the applicant, the plaintiff, may file or bring an application for summary judgment on the basis that they believe that the defendant is only filing the plea malified, they don't have bona fide defense.
Yes.
Yes.
And the term usual order in summary judgment applications, what does it generally refer to? If one says the usual order was granted?
It means that I can't answer that.
Yes. All right. Lastly, the reviews, one can bring the reviews in terms of PAJA or as a legality review. Are there timeframes that are applicable in bringing these reviews?
Yeah. Yes, Section 7(1) of PAJA provides that such applications can be brought within the period of 180 days. That is 6 months.
Yes, and the legality review?
Not PAJA.
Yes.
Yes. I think it is not regulated in terms of PAJA. The review application can be brought within a reasonable period after the decision was made.
Yes, thank you. Thank you, DC Jane.
Thank you, JP. Premier, do you have questions for this candidate?
Thank you very much, DJ. Good afternoon, Mr. Zaca. My one is just on the from the LSSA about the fact that the typographical and spelling errors, particularly in relation to the fact that it's the form that was being filled by Mr. Zaca that has got that questionnaire that has got so much spelling and typographical errors. I'm just trying to really find out, is this normal that you would have such errors, Mr. Zaca?
Yes, thank you, Premier. No, it's not normal. As I I'm saying that maybe it was attributed by the fact that at the time of completion of this questionnaire, I was not well, but that cannot be used as an excuse. But normally, I don't have such typographical errors.
Do you have more questions, Premier?
Just the last one, Jay. Just to understand, will this perhaps be an indication that you might still be needing more exposure and experience in this regard?
It may be, I will, if this commission decide otherwise, I will accept the invitation to have more acting stints, but that is not normally what is happening, that I have a lot of typographical errors.
Thank you, TCJ.
Thank you, Premier. Just to follow up on this issue of typos, Mr. Zaca, when the JP asked you about this, I did not hear you express any contrition for your sloppiness, because your application papers are just sloppy, including some of your judgments, by the way. One picks up a number of typos there. One judgment being the insolvency one, which in which you proposed in granting an order. You repeated that erroneous statement twice, but then I'm prepared to grant you pardon, because I know how hectic things can be in the High Court, and if you don't ask somebody else to proofread your work, it is very easy. We all make this kind of mistakes. That's why you need to be careful and always ask to have another pair of eyes looking at your work before you send it out. So I'm willing to forgive you for the typos, but your attitude does not show that you understand that being meticulous is one of the hallmarks of a good judge. You cannot be a sloppy judge. The two words don't go together. Do you get that?
Yes.
So you do recognize that you could have done better.
Yes,
you should not have sent the JSC papers that are riddled with these careless mistakes.
Yes, I do appreciate DCJ.
Applying for a high judicial office.
Yes, DCJ.
Okay, thank you. Professor, DM?
Good afternoon, Mr. Zaca. No, I don't have any questions, DCJ.
Okay, thank you. Prof?
Thank you very much, DCJ. Good afternoon.
Yes, good afternoon, Commissioner.
I just want to mine is a very short one. I just want to take you to the case that you have just conversed with the JP, the one that deals with liquidation and National Credit Act and all those issues. I'm not sure. Do you have it?
Yes.
Paragraph 30 of that decision. Well, it is commendable that you were able to produce such a judgment in 5 days. I must say, because this is one of the most difficult areas of our law: interaction between company law, National Credit law, and insolvency law. But I mean, you deal with, I think the parties pleaded factual and commercial insolvency. Yes, and or in the alternative, that if they don't get one, they might as well get another one, and you dealt with that. Yes. But there is something that really I was not sure what you actually meant in paragraph 30, where you say, in 1, 2, 3, 4, 5, 6, 7, 8, in like the 8th line from the top, or perhaps maybe let me start where the sentence actually starts. Well, in light of the above circumstances, and more particularly respondents' failure to pay its contractual debts which prima facie exist, including failure to make partial payment, I find that the respondent is factually and legally unable to pay its debts. I'm just concerned about this legally. What does it mean that somebody is legally unable to pay debts? That's what kind of like confused me as to what you were explaining there. What does it mean that somebody is legally? I mean, if you cannot pay, you cannot pay. How does it become legally? How do you become legally unable to pay? I'm not saying you are wrong. I just want you to enlighten me.
Yes, thank you, Commissioner. My reasoning there was that due to the fact that the respondent had failed, firstly, there was a default judgment which had been granted against the respondent, of which that default judgment was not rescinded. So legally, they were unable to pay.
But that's the part that I don't understand.
Yes.
Because if I owe you, and I'm not saying you are wrong, I just want to understand for my benefit, perhaps for my students who are watching. If you owe me and you are unable to pay me, I think that is as a matter of fact, you are unable to pay me. So you cannot give me the money. Like practically, you cannot give me the money. I just want to understand this legally. Like, how do you legally become unable to pay somebody? Are you prevented by statute from paying, perhaps maybe, or the constitution? Or like, how do you become legally unable to pay somebody?
I was not referring to that. I mean, to that maybe any piece of statutes obliged the respondent to pay. But I was looking at the fact that there was a default judgment that was taken against the respondent company, which remained unrescinded. And the inability to pay was a matter of fact. And yes, the other word that I could have used was contractually bound to pay, because this large credit agreement, which was extended to the respondent, was in fact in terms of contract.
No, it's fine. Like I said, I cannot work it out in my mind as well, so you might well be right. Thank you very much, DCJ.
Any more questions for the candidate, colleagues? No. Well, we've reached the end of your interview, Mr. Zaca. Thank you for making yourself available for this position. You're excused.
Thank you, TCJ and the commissioners.